The handling of offers in real estate transactions is one of the most sensitive and legally regulated aspects of a licensee's responsibilities. Having already explored the requirement to promptly present all offers to clients, it is equally critical to understand when and how offers may be disclosed to others, or when a licensee may lawfully stop submitting new offers to a client. These rules exist to protect the integrity of the negotiation process, ensure fairness among buyers and sellers, and uphold fiduciary duties under ARS. Section 32-2-151.01G and Commissioner's Rule R4-2-8-1101A. A licensee's authority to disclose offers to third parties or cease submitting offers is determined entirely by the client's written instructions. Without such authorization, a licensee must treat all offers as confidential and continue submitting everyone to the client as soon as practicable. This obligation arises from the fiduciary duties of loyalty and confidentiality, which require that a licensee act solely in the client's best interest and avoid revealing confidential information without consent. For example, a seller may instruct the listing agent in writing that once an offer has been accepted, the agent may cease submitting subsequent offers. Alternatively, a seller might direct the agent not to disclose the terms or existence of an offer to any other potential buyers. In both scenarios, the agent must adhere strictly to those written instructions. Any deviation from them, such as revealing offer details without consent, could result in a violation of R4-28-1101A for dishonest or unprofessional conduct and disciplinary action under ARS. Section 32-2153A3. However, there are cases where disclosure is permitted or even advisable if authorized by the client. For instance, a seller may instruct their listing agent to inform other buyers that multiple offers exist to encourage competitive bidding. While the agent may confirm the existence of multiple offers, they must never reveal the specific price, terms, or conditions of any offer without the seller's explicit permission. This restriction protects the client's negotiating position and ensures compliance with Article 1, Standard of Practice 1-13 of the National Association of Realtors (AR) Code of Ethics, which mirrors Arizona's requirements for confidentiality and fair dealing. Another situation arises when the client provides written instructions to cease receiving new offers, often after a binding contract is in place and contingencies have been satisfied. For example, once a seller and buyer have entered into a fully executed purchase contract, the seller may wish to stop considering backup offers. In that case, the listing agent must document the seller's direction in writing and retain it as part of the broker's transaction file for at least 5 years, as required by ARS. Section 32-2-151.01A. Without such documentation, the agent remains legally obligated to continue submitting all offers. Conversely, in situations where a seller wishes to continue receiving backup offers even after one has been accepted, the listing agent must still present those offers promptly. The key difference is that the seller cannot legally accept another offer without first properly canceling or releasing the existing contract, unless the backup offer is expressly contingent upon the failure of the primary contract. For buyer's agents, disclosure of competing offers is also governed by the client's consent. A buyer's agent may not reveal the buyer's offer terms or interest in a property to other sellers or agents without the buyer's permission. Doing so would compromise the buyer's negotiation position and constitute a breach of confidentiality under R4-28-1101. This rule reflects the broader legal concept that all client communications relating to price, motivation, or negotiating strategy must remain private unless disclosure is authorized in writing or required by law. There are also specific statutory and ethical exceptions where disclosure is necessary to maintain transparency and fairness. For example, if a licensee has an ownership interest in the property or represents a party with a direct financial interest, the agent must disclose that interest to all parties under R4-28-1101. This requirement ensures that all participants in the transaction are aware of any potential conflicts of interest that could influence the handling or disclosure of offers. One of the most common misconceptions among new agents is that once a contract is under contract, they no longer need to present new offers. This is not true unless the client has specifically stated otherwise in writing. The Arizona Association of Realtors Residential Resale Real Estate Purchase Contract reinforces this by providing that sellers may accept backup offers, and buyers may submit new offers until close of escrow. Thus, an agent who fails to submit a new offer when the client has not directed otherwise risks disciplinary action for violating the duty to act in the client's best interest and promptly present all offers. Case law reinforces these principles. In re Hollingsworth, ADRE disciplinary case, 2011, a listing agent was sanctioned for failing to deliver subsequent offers to a seller after one was accepted, even though the seller had not given written instructions to cease consideration. The ADRE concluded that the agent had improperly limited the client's opportunities and failed to act expeditiously under R4-28-1101. This case illustrates that the agent's duty continues until the client expressly limits it in writing. In summary, disclosure and submission of offers are governed by three essential principles: client consent, documentation, and promptness. Every licensee must balance their fiduciary duties of loyalty and confidentiality with their legal obligation to keep clients informed of all material opportunities. When in doubt, the safest approach is always to disclose to the client, not to others, and to document every decision clearly in writing. Review summary. Licensees must promptly submit all offers to their clients, unless the client has provided written instructions stating otherwise. Under R4-28-1101, disclosure of offers to other parties may occur only with the client's authorization, and confidentiality must always be preserved. Sellers may direct agents to stop presenting offers after acceptance of a contract, but those directions must be written and retained in the broker's file. Unauthorized disclosure of offer terms or failure to follow client instructions can result in disciplinary action, ethical violations, and potential civil liability. Discussion prompts. Why must offer disclosure to third parties be authorized by the client in writing? Answer: because it protects the client's confidentiality and negotiating position and ensures compliance with R4-28-1101A and fiduciary obligations. When may a licensee legally stop submitting offers to a client? Answer: only when the client provides written instructions to cease submission, such as after accepting a binding offer. Why is documenting client instructions essential in offer handling? Answer: written documentation ensures proof of compliance, protects the agent in case of disputes, and fulfills ARS Section 32-2151.01A record-keeping requirements. Closing remarks. In real estate, how a licensee handles offers speaks volumes about their professionalism and integrity. The law demands transparency with clients and discretion with others. Licensees must act as trusted advisors, faithful in communication, respectful of confidentiality, and diligent in documentation. When in doubt, the best practice is simple: always act in the client's best interest, promptly, and with clear written records.